SJC-12964 in the matter of an impounded case.
We will hear from Mr. Hahn first.
Yes, good morning, Justices. May it please the Court, Peter Hahn for the juvenile in this matter arising from 3 reported questions from the Norfolk County Juvenile Court related to Wallace W. hearings. I plan on addressing the second and third questions that are reported, as the first question will likely be addressed in the matter after this one. However, I am happy to and available to answer any questions related to this matter, as well as any issues that arose in the brief. The second reported question is whether or not in Wallace W. hearings the rules of evidence apply, or essentially what are the evidentiary standards for Wallace W. hearings. And what you have to do is go back to what Wallace W. was really all about, and that was the exclusion from the jurisdiction of the juvenile court for delinquency matters for first offenses of 6 months or less misdemeanors. And Wallace W. ruled that that required a prior adjudication. However, because that would have created a catch-22 that the legislature did not intend, the Wallace W. court and decision created the prearraignment Wallace W. hearing, where the Commonwealth had to prove a prior offense beyond a reasonable doubt. So this is a jurisdictional hearing, and the standard is beyond a reasonable doubt. So the evidentiary standards or rules of evidence that apply to trials apply to Wallace W. hearings.
Well, sorry, counsel, wouldn't it be more akin to, I mean, like in so many other cases, probation hearings or probably the old bind-over hearings, the rules were very relaxed.
Your Honor, in those matters that you reference, as well as others referenced in my brief, the evidentiary standard or the burden of proof, is lower than beyond a reasonable doubt. Wallace W. was clear that that burden of proof here is beyond a reasonable doubt. And if you look at other hearings where the standard is beyond a reasonable doubt, evidentiary standards that apply to trials apply to those hearings. So you can look at civil commitment proceedings under Chapter 123. Even last week, there was a decision by this court in Ray J.P. that referenced the inadmissibility of hearsay in Chapter 123 proceedings. There are sexually dangerous person trials where hearsay is generally not admissible. However, the statute specifically related to those trials does allow in a limited amount of specified hearsay. But that is where the statute allows in the hearsay, which is the exception to the rule, which the case law related to 123A makes clear.
Can I make a question? Can I ask a question, please? No, I'm sorry. Go ahead. Go ahead, Justice Lowy. Go ahead.
Please, Justice Link.
You sure? All right.
Yes, please.
Okay. All right. Mr. Hahn, I was wondering whether you could tell me what it is that you think that the Commonwealth has to prove at the Wallace W. hearing.
The Commonwealth has to prove the equivalent of what the Commonwealth would have had to prove for the prior adjudication. So that is all the elements of the underlying offense that would have been the prior offense.
In your case, what would the Commonwealth have to prove?
So in this case, just to establish, there are 2 counts in this case. The qualifying minor misdemeanor is the annoying and accosting another person charge, and there's an assault and battery. These were brought forward in one complaint, so they were joined. This is essentially one set of allegations before the court. So actually in my case specifically, I don't believe that the Commonwealth could actually prove a prior offense based on the record before the court and my client's history to even move forward. If there were a Wallace W. hearing in a case, that would be the Commonwealth having to prove each of the elements of the prior offense or the supposed or claimed prior offense beyond a reasonable doubt.
Would that have to have been something that had been adjudicated or not?
According to Wallace W., it's either a prior adjudication, or if there is no prior adjudication, then the Commonwealth can prove a prior offense, a prior alleged offense, beyond a reasonable doubt to establish or get over the jurisdictional hurdle. So
let me continue asking the question though, because I puzzle over this. I don't understand what it is that the bearing of this would be on a case like yours, where you have this other offense left over anyway. Do you not? I mean, even if you could show that on the basis of this child's record, he had no record. And I don't even really know what that means. He has no record. He has no record of adjudications. He has no record of involvement with the juvenile court. Or what does it mean to say he has no record?
He has no record of prior adjudications, and he has no formal record of involvement with the juvenile court. So that typically means that he has not been arraigned. So once he's arraigned, an entry appears on the record. And in fact, that was what the Wallace W decision and court made explicitly clear, that that once you are arraigned on that offense, which unless it's established that there was a first offense prior, then there is an entry on your record, your juvenile record, for that qualifying minor misdemeanor. So it is important for the Commonwealth to establish a prior offense beyond a reasonable doubt, so that there isn't that error of one or possibly more qualifying minor misdemeanors on your record. So there is a prejudice to any additional charge going on the record or going forward with that offense.
Your case, you've got two offenses here. One which is clearly over the threshold, right? And we said in Wallace W that you can go direct, the Commonwealth can go directly to prove the one over. So we're really dealing with, what do we do with the 6 month or under misdemeanor?
Yes, Your Honor.
And, you know, for what rules apply, we don't do, isn't this a Matthews versus Eldridge type of analysis that we've got?
You're right. Sorry to interrupt.
No,
I disagree. I do think the Matthews versus Eldridge procedural due process balancing test applies to the third question. It does not apply to the second question around the evidentiary rules at the Wallace W hearing, because this is strictly jurisdictional, and it's clear that the standard of proof is beyond a reasonable doubt. And in, as I said before, other areas of the law where the hearings have the beyond a reasonable doubt standard, hearsay is inadmissible unless otherwise dictated by statute.
So our cases, we've said in our cases that whenever you have a beyond a reasonable doubt standard, the rule, no hearsay is allowed. You have to comply strictly with the rules of evidence, even though the ultimate result of this kind of adjudication is basically no penalty. It's basically going to be the dismissal of the first offense, or it's just recorded as a first offense, right? So the consequence to the juvenile is not like any of the other types of cases we've been dealing with, right?
It would be the dismissal of a charge where a first offense or prior offense had not been proven beyond a reasonable doubt. And there are a number of consequences that come along with a charge moving into the juvenile court system at arraignment, where a jurisdiction would have to be established. So it's not only the entry of the charge on the juvenile record, but it's going all the way to the opposite end of the process in the spectrum, that that juvenile could be committed to the Department of Youth Services until his 18th, 19th, or 20th birthday, depending on the circumstances. You also have conditions of release that could be imposed at or after arraignment, that could be restrictions, or that would be restrictions on that juvenile's liberty. So there are many consequences that go along with having a charge move formally into the process at arraignment.
Mr. Hahn, certainly as we figure out what these Wallace W hearings look like, the fact that the standard is proof beyond a reasonable doubt is certainly a factor that inures to your client's favor, no doubt. But these Wallace W hearings don't require a jury trial. Clearly, there's not venue issues if you have to prove an offense from a different county. So ultimately, in trying to resolve whether the law of evidence applies, I think we sort of have to get to some of Justice Kafker's points about what are the implications of this hearing, and it being a procedural due process issue. Because certainly in United States versus Salerno, with clear and convincing evidence in order to be held on dangerousness, the implications are more than they are here. Certainly in a violation of probation, the implications are greater than they are here. So why is it? I understand proof beyond reasonable doubt is a factor that certainly is in your client's favor. But why is that dispositive? We're trying to figure out what the legislature meant here with a statute that doesn't give us a lot of help.
The Wallace W decision, at least in my reading, was pretty clear, let's say starting with witnesses being necessary. And for me, that is an indication that the Wallace W decision meant that there has to be testimony at a hearing that is essentially like a mini bench trial, if you will. As you pointed out, certainly there's not a right to a jury trial, at least according to Wallace W for the Wallace W hearing. Building off of what I was saying before, I do see a lot of interest on a juvenile's behalf, including my juvenile's behalf, by having that even a minor misdemeanor charge go into the process. And it could be more than one, depending on if in another situation there's an additional case.
Your case, why is because your case, the assault, does the assault and battery occur first? The more serious offense occur first?
The Commonwealth has said, based on part of the filing, that the assault and battery is alleged to have occurred first. However, if you look throughout the record, that's before the court, that's not clear. And as I said before, the charges are joined in a complaint, which was the Commonwealth's charging decision. So even if...
Well, let me just push you for a second, Mr. Hahn, because I'm trying to understand. This is messy, as we know. So the Commonwealth can proceed on the more serious one and prove it at trial. So, and can arraign your client on that. There are no Wallace W issues there. So they can proceed and go forward. So what we're dealing with, okay, then if you win and that case goes away, then we can move to the Wallace W proceeding. And again, the ultimate consequence of this will be at worst for your client that they establish a first misdemeanor, right?
Your Honor, in your question, it sounded like you're saying that in that scenario that my client would be arraigned on the assault and battery, he would go to trial and then either win or lose. Is that the question?
Well, to me, that Wallace W isn't clear on a lot of things, but it seems that it's clear on that point, because that we said expressly that you can proceed on the more serious offense without a Wallace W proceeding. The legislature,
I agree, Your Honor.
So we're really struggling with how we handle that lesser misdemeanor, whether you can arraign on it while this thing is going on, what kind of proof you need. And I understand it's tricky, just as Justice Lowy says about the rules of evidence. It is a beyond a reasonable doubt standard, but we also talk about how difficult this is going to be. These are going to, sometimes we're going to be resurrecting from different counties, older offenses.
That may be true, but we have the Wallace W decision itself, which said very clearly that if a prior offense is not proven beyond a reasonable doubt, whether essentially by that prior adjudication or at the Wallace W hearing, no complaint or no minor misdemeanor charge can be arraigned, can go forward. There can be no jurisdiction there. And because, in part, consistent with the legislature's intent, that you don't want this erroneous record of the offense and everything that goes along with it. I go back to, this is one complaint here in this specific case. If you have two separate cases, you're in a different situation. I do not believe that's the situation before the court. I agree with you, Justice Kafker, that the Commonwealth could proceed on the assault and battery, but according to Wallace W, for the annoying and accosting, there has to be proof beyond a reasonable doubt prior to arraignment on that offense of a prior offense. In the circumstances of this case, the Commonwealth does not have that.
Mr. Hahn, go ahead, please. I'm sorry.
I was going to move on to the other reported question, unless Your Honor has a different question.
No, please.
The other reported question, the third reported question about if there are any discovery obligations or the equivalent of discovery obligations prior to Wallace W. As I lay out in my brief, Wallace W, since it is essentially like a mini trial, you want to prevent that trial by ambush. So I lay out, according to the Matthews v. Eldridge balancing test, the interests at issue and set
Mr.
up
Hahn,
what I...
has the juvenile court, is there any standard approach to discovery going on in the juvenile court at this point, or is each judge sort of making it up as he or she sees fit?
I'm not aware of any guidance from the administrative office, Your Honor, and my understanding from hearing from attorneys in various counties is that each county and each judge is essentially doing something different until there's further guidance from this court.
Any further questions?
Like thank you.
Okay, thank you, Mr. Hahn. Ms. McLaughlin?
Good morning, Your Honors. Assistant District Attorney Laura McLaughlin for the Commonwealth. The Commonwealth appears before you today to answer 3 reported questions by the Norfolk Juvenile Court. Prior to answering those questions, it is the Commonwealth's position that although in this case it did move for a Wallace hearing, the juvenile was not entitled to a Wallace hearing, as he was charged simultaneously with a 6-month or less misdemeanor and a greater offense. The legislative intent of granting a second chance to juveniles for isolated misdemeanors would not be served, whereas here the juvenile engaged in a pattern of targeted misbehavior and crimes against the same victim.
I don't understand. So if you have any type of multiple filing, if you file 2 misdemeanors under 6 months, no hearing in your view?
It's the way Wallace W is written in what is contained in footnote 6 is that if a clerk may issue a complaint if the if the Commonwealth notifies the clerk that the Commonwealth intends to prove multiple offenses.
Well, that's the complaint. That's separate. That's a whole different issue. So if you just by filing, I understand here we have a more serious offense. That's different. But I don't understand your argument, because so you go ahead with your more serious offense and you lose. Mm-hmm. Then this person has got to be entitled to a Wallace W proceeding because they may not have a first misdemeanor. So I don't understand, just because your charging decisions can't determine that.
Well, the legislative intent is to not have juveniles enter the court system if they are subject to a 6-month or less misdemeanor only. Where here the juvenile has committed a greater offense, he's already entered the juvenile justice system. The legislative intent to keep juveniles out of the court system is not served. Where
No,
he's
I understand that. I understand that part of it. But again, if you lose on the bigger one, then there's still an issue whether this juvenile is entitled to a clean slate and having that other one dismissed. So I understand this is messy, but doesn't the juvenile have the ability, to prevent arraignment or anything else on the lesser offense, at least if it occurred prior to the second offense? I mean,
as the law is written, no. If the legislature was to determine that a juvenile could move to vacate prior arraignment on a first offense misdemeanor, that's a possibility. However, at the time the Commonwealth is proceeding forth, if there is probable cause for both offense, the greater offense and the lesser offense, the Commonwealth can proceed and do.
Where in Wallace W or the statute, particularly where in the statute, is there anything like that? The idea is the legislature is saying a first offense misdemeanor, if it's the first offense misdemeanor, there should be no arraignment on it and nothing.
Unless the Commonwealth intends to prove multiple offenses.
No, that can't be that's got to be overbroad. Just because you've got to prove something first. You don't get to just do it. We rejected the probable cause analysis in Wallace W. Probable cause is not enough.
Well, a potential remedy would be for the juvenile if they were found adjudicated delinquent on the less offense or adjudicated not delinquent on the greater offense, and the only entry would be 6 month or less to misdemeanor. That juvenile could then move to dismiss as no jurisdiction, or they could also move to seal any record. But at the start of the case, if the Commonwealth intends to prove multiple offenses, and where in this case it is a greater offense of an assault and battery and a minor offense on the same victim, it would be the most judicial efficiency to proceed forth on both cases, both offenses at the same time.
So it's a judicial efficiency argument. It's not a statutory argument.
It's a combination in both. The statute allows this, where here it's a pattern of targeted misbehavior and crime against the same victim, and the juvenile has already entered the system. It would be an ineffective use of resources to hold off, and in this case, it'd be the same evidence, the same witnesses, to then have a secondary trial after conviction.
I agree with you. There's some, we want to avoid unnecessary duplication. But so, like in your case, and again, I don't want to confuse the two cases, but in your case, the Commonwealth moves for a Wallace W hearing on the more serious offense, or at least both of them, right? It decides to prove the more serious offense in a Wallace W rather than just going to trial on that. Why did they do that? That's wasteful and a duplication of effort.
I think the Commonwealth erred on the side of caution to make sure there was jurisdiction, given the confusion in the statute and the case law. The Commonwealth did file notice that it intended to prove a Wallace hearing. It summons witnesses, it summons records. The Commonwealth was prepared to go forward at that Wallace hearing to prove that.
To prove what? To prove what? The lesser or the greater offense?
To prove the greater offense, the assault and battery.
Why would you do that? Why wouldn't you just proceed to trial on the greater offense, which you could have done? If duplication of effort is your concern, why not just proceed on the greater to trial, prove it, and then the other one can either be dealt with in a Wallace W proceeding or not at all. If you want a trial, it doesn't matter, right? The second offense, I'm just not sure.
Well, here the assault and battery occurred at least 2 weeks prior to the other offense. Here, what should not and cannot be overlooked is the victim. In this case, there's a victim who is afraid to go to school. She's been targeted, she's been assaulted, she's been hit. There's been a number of incidences that makes that victim feel unsafe.
I totally agree with that, but aren't you're putting that victim through a second proceeding by doing the Wallace W on the more serious one, then you're putting the victim through it twice, right?
Not with the Commonwealth's position, and if I could turn to the second reported question, is regarding what the evidentiary standards are at this hearing. It's the Commonwealth's position that the rules of evidence do apply. However, in those rules, reliable hearsay is permitted. What that reliable hearsay is would depend on the facts and circumstances of each case.
Can I interrupt you for a second and ask you if you can give an example of a situation where something is being asked to be proven by beyond a reasonable doubt and the rules of evidence do not apply?
Your Honor, in Chapter 123, Section 8, civil commitments of involuntary civil commitments of mentally ill people, the court does allow a hearsay to be admissible for those commitment hearings.
And has to be proven by beyond a reasonable doubt?
Yes, Your Honor. The appeals court recently addressed that in the matter of JD 97 Mass App 15, a 2020 decision. But the court does need to find beyond a reasonable doubt in those civil commitments. It's the Commonwealth's position that has a higher grade of liberty interest than the arraignment of a juvenile.
Okay, so that's the only example you can think of? Or are there others?
That's the only one that comes to mind at this point.
Okay, fine.
I know the other more criminal statutes, the burden is less for probation surrenders or bail
Yeah,
revocation.
but I'm just saying that the problem here is that the burden is not less, it is beyond a reasonable doubt.
No, I think the burden beyond a reasonable doubt provides a safeguard to juveniles.
Because it's
that the
essentially the
Commonwealth-
adjudication of the thing below, right? It's saying, Commonwealth is really trying to prove that if there is no prior record, that they should have been, right? That there's something happened that should have been.
Yes.
And so that has the equivalent really of trying to prove it at trial, right?
It's the same burden of proof that the judge has to find that the
Kind
Commonwealth.
of same elements, right? Same kind of elements.
Yes, but here it's the balancing act. It's a pre-arraignment. It's not an adjudication. It's a determination whether the Commonwealth can proceed and arraign the juvenile on that offense.
Yeah.
That beyond a reasonable
Not on that offense, on another offense, right?
correct, but that standard remains. So a juvenile judge is in the best position to assess what evidence is admissible.
Yeah.
Whether the Commonwealth can introduce reliable hearsay would depend on the facts and circumstances of that case. If the Commonwealth did admit hearsay statements, the juvenile judge would still have to determine whether the has met its proof beyond a reasonable doubt. So that's a balancing act that safeguards the juvenile and also lets the Commonwealth in certain circumstances admit reliable hearsay if relevant and appropriately deemed by the juvenile judge. If I could then turn to reported question number 3, it's the Commonwealth's position. They are in agreement that there should be an exchange of discovery prior to arraignment. However, the Commonwealth feels that the juvenile judges may make the determinations whether what the appropriate standards of time are, depending on the facts and circumstances of each case.
Can I ask a question here? Do you stand by the, I was very confused when I was reading the brief. It seemed to me that you were saying that you shouldn't be having to answer these reported questions at all. Is that still the position of the Commonwealth?
No, Your Honor. The Commonwealth appears before you today. They would like the court that we are here today to answer those reported questions. But what is driving behind this is the Commonwealth would like this case to be remanded back to the Norfolk Juvenile Court for the juvenile to be arraigned on both offenses and to proceed in due course, as there is a victim who is very much anxious for the Commonwealth to continue on with the case.
So I guess my question is you, despite the fact the Commonwealth asked for a hearing in this case, you're saying that you don't want the hearing at all?
The Commonwealth feels that although it did move for a hearing, it was not required. However, if the court was to rule differently and for a Wallace hearing to be required, given the interpretation of the case law and the statute, the Commonwealth would like the case to be remanded back in accordance with the decisions of this court.
The Commonwealth could just proceed, correct? They could just proceed on the more serious one. Nothing's preventing you from going ahead on that one, correct?
He has been arraigned. There was some, I would have to confer with the docket of the status of the case, but I believe it's in a holding pattern right now, depending on the decision.
It's in a holding pattern because you're insisting on holding a Wallace W proceeding on. You're the one who's caused that to happen. Did the defense even ask for a Wallace W? Did juvenile even ask for a Wallace W proceeding?
I believe they filed for one. They also filed a motion for diversion that was denied, and the juvenile has entered the justice system. He has been arraigned on the assault and battery offense. The Commonwealth in the Norfolk Juvenile Court reported these questions to make sure there was proper jurisdiction to clarify the outstanding questions that have been posed by the statute and to make sure that no one is arraigned who shouldn't be arraigned, and that there's proper jurisdiction for the Commonwealth to proceed.
Counsel,
if I could just review your position. So your view is that the two charges should proceed together for a number of reasons, including, you didn't mention it, but including much of the accosting might be relevant evidence on the assault and battery, and also so that there's not two separate adjudications. And if the charges proceed together and the defendant is found, the juvenile is found not delinquent of the more serious charge for which a Wallace W hearing would be not required, if they're found not delinquent, then if it's a delinquency on the less than 6-month misdemeanor, that delinquency would be vacated.
Yes, Your Honor.
And that's your position, right?
Yes, Your Honor.
Okay, thank you.
Counsel, I have one quick question that might not be that, the answer might be harder, but, and this, I understand if you don't know the answer. This statute has presented us with an analytical, a lot of analytical complexity. Is there any point at which a statute becomes impossible to implement and that's a ground for invalidating it? It's never anything I've seen in the statutory interpretation law, but
I'm not
they
aware
didn't
that-
mean this mess, right? The legislature did not intend to have this be so hard.
I would agree with that, Your Honor. I believe that
maybe they did want these misdemeanors to be, off the scale. Maybe they did make this difficult deliberately because they don't want you chasing these smaller ones. So maybe there is some desire to make this burdensome.
The Commonwealth's position is that the legislative intent is to grant juveniles a second chance for isolated misdemeanors. Where a juvenile continuously engages in a pattern of crime, the juvenile justice system is meant to rehabilitate juveniles and to provide them assistance and to provide them counsel. If a juvenile continues to commit crimes, they should enter the juvenile justice system to be rehabilitated and to obtain assistance from the juvenile court prior to becoming an adult. So if it's a continuous pattern of behavior and it's multiple offenses, it's appropriate for the juvenile to be arraigned and for the Commonwealth to proceed in due course.
Can I just push back on that? Because I get that point totally. If we have a pattern of behavior that we want the juveniles, that we want that addressed, but the problem here is we have two acts. One that fits under the misdemeanor, the lesser misdemeanor category, and one that's not. So that makes this harder than sort of a pattern of behavior. It's two incidents, meaning that if the first one, say he did both of them, the first one the Commonwealth can proceed on, arraign, and prove, and the second one, even if it's proven, if it preceded it, it would be dismissed as a first misdemeanor. So it's tricky.
It is tricky, but here, both incidences involved the same victim. It was the same continuous stream of events targeted against the same victim.
I get that, but again, if you prove this more serious offense, the victim is protected again on that matter, but we can't do anything about the earlier one because the legislature made a decision that if something is someone's first misdemeanor offense, it's not held against the juvenile. So it's just, this is difficult under that conceptual framework.
Yes, Your Honor, but as my time has ended, I would just like to conclude that the Commonwealth respectfully requests the case be remanded back to Norfolk Juvenile Court to proceed with the guidance of this court's decision. Thank you very much.
Thank you, Counsel.